Today is 9th August 2023. So for the today's session of the series, the keynote speaker is with us, Honorable Dr. Mahesh Laxmanrao, Dharmapurikar sir. So first of all, I welcome to you sir for the dais. Then I welcome to the chief organizer of the series, Honorable Principal M. Bedkar sir. I welcome the colleagues from my college, Dr. Sanjay Kale sir, Dr. Anita Dole madam, and all others. And lastly, I heartily welcome all those dear participants. The topic for today's presentation is Judicial Response for the Protection of Environment. Now this topic is going to present, as I have said, the keynote speaker, Honorable Dr. Mahesh Laxmanrao Dharmapurikar sir, who is a in charge principal in Shri Shivaji Law College, Kandhar, from district Nanded. So with this brief introduction, now I request Honorable Dr. Mahesh sir, please start your presentation on the topic Judicial Response for the Protection of Environment. Welcome sir, you are heartily welcome. Please start your presentation. You unmute sir. Mahesh sir, you unmute yourself, your voice is not coming. महेश सर तुम्ही अनम्यूट करा आणि मग बोला. महेश सर तुम्ही अनम्यूट करा व एक ते बटन आहे ते अनम्यूट करा आणि मग तुम्ही बोलते व्हा. माईक अनम्यूट करा. एक माईकचं बटन आहे वरी ते अनम्यूट करा म्हणजे मग तुमचा आवाज येईल. हॅलो हॅलो हा सर तुमचा आवाज येतोय आता. यस यस तुमचा आवाज येतोय. येतोय सर तुमचा आवाज येतोय आता. हा ऑडिबल येतोय सर. मी विजिबल आहे. विजिबल नाही आहे. ऑडिबल आल्सो. ऑडिबल सर. नो स्टार्ट युअर स्टार्ट युअर पीपीटी.
Okay, first of all, thank you for giving me an opportunity, and I congratulate Dr. Bedkar sir for arranging world record and webinar series, as well as I giving my best wishes for his birthday. Today sir is celebrating birthday. In spite of that, he is giving his valuable time. Really, I salute to your efforts, and I welcome all the respected participants, respected my senior colleagues, etc. So my presentation is on judicial response on environment protection. No doubt the world is facing nowadays the important problem among terrorism or other problems are considered. The protection of environment is the most important problem. As far as my lecture is considered, the synopsis of my lecture is on first is how the protection of environment is most necessary, most important. What are the changes as far as acts is implemented, enacted by the government of India or state governments? How the various laws are passed by the state legislatives as well as the parliament by giving a landmark
Sir,
judgment by Honorable Supreme Court.
sir, hello, sir.
Ah, sir.
You start the PPT presentation, sir.
Sir, PPT is not with me, sir.
Okay, okay, no doubt. Please
Is it
continue. Please
compulsory?
continue.
Is it compulsory, sir?
No, sir. I
PPT.
think you are available
So
so that
PPT is
I
not with
got.
me, sir. PPT is not with
Okay,
me, sir.
okay. No problem, sir. Please continue. Very sorry. Please
Whether I am
continue.
visible or not, sir. Whether I am visible or not.
You are visible, sir. No doubt. And your sound
No
is
doubt.
also getting. We are getting your sound and you are visible. No doubt.
Okay. How I can operate
Please
now
continue.
because I think some network problem
No,
is with
no.
me.
No, sir. You are
Can I?
visible. Visible. Yes, sir. Please continue.
Yeah. So first of all,
Yes.
as far as the brief synopsis of my lecture is considered, how the landmark judgments or the vital role played by Indian judiciary regarding the protection of environment, and by that landmark judgment, how the changes are carried out on national level or on state level. And lastly, the most important thing is that sustainable development, that is long list of important principles passed by our Indian judiciary, that is polluter pays principle, protection of environment, precautionary principle, etc., are discussed in this lecture. So first point, no doubt, the protection of environment, control of pollution is important. In Indian Constitution, initially when came into force in the 1950, no direct provision is made in the Indian Constitution for the protection of environment. The Stockholm Conference is held in the year 1972, and by that conference, the consciousness, awareness among the environment is started. Our late Prime Minister, the then Indira Gandhi ji, participated in that conference, and long list of principles are discussed passed in that conference, and one of the most important principle is that now from 1972 onwards, protection of environment is the most important, and the participated countries must make a respect to laws, make constitutional amendments, because as far as India is considered, Indian Constitution is the basic law of land. All laws are derived from Indian Constitution. The Indian Constitution, no doubt, is having place of pride. That's why from 1976 onwards, amendments are carried out in the Indian Constitution, and most important one is 42nd and 44th Amendment in the year 1978 onwards. And the direct provision made in the Constitution for the protection of environment. The responsibility lies on the shoulder of individual as well as on the state and national level. When any direct provision made in the Constitution, or if any specific law is enacted by the Parliament or state government, in such cases, our Indian judiciary take a bold view, pass a judgment, and take a dynamic approach. No doubt, our Indian judiciary has specially High Court under Article 32 and High Court 2 to 6 and 32, Supreme Court is having public interest litigation. When Dr. Babasaheb Ambedkar is asked which is the most important article in the Indian Constitution, immediately Dr. Babasaheb Ambedkar replying that constitutional remedies, that is Article 32, is the soul of our Indian Constitution. And Article 32 is no doubt constitutional remedies. Means if any right is violated by any government, maybe on state level or by our central government, immediately the remedy is available under Article 32 of the Indian Constitution. Under Article 2 to 6, a remedy is available on state level, that is state courts or high courts. This is first part. After 1976, the awareness, consciousness, as well as industrial growth is started. Western countries already accepted or giving a much more importance to the financial earnings or for development. For development, industrialization is the most important source, and through that industrial growth, initially from 1980 onwards, exploitation of environment is started. On one side, growth is started, industrialization is started for financial stability, industry, industrialization, working to the peoples, etc., is important. But as far as the impact or effect of industrial growth, industrialization is considered from 1990 onwards, from 1976 to 1990, a new view, a new way of thinking is developed in the mind of Western countries or in the mind of developed countries, that no doubt on one side growth is important, earning is important, financial stability is important, industrialization is important, but by that growth the environment is exploited, natural resources are not protected, some chances of excessive use of natural resources. Such a type of thinking, only thinking is started, not awareness, not consciousness. Hence, from 1980, how this exploitation of natural resources or pollution may be controlled, on that way the thinking is started. And by that, during that period, constitutional amendments are carried out, and directly in Indian Constitution, under Article 51, under Article 48, A, B, C, etc., the provisions are directly mentioned to protect the environment by the individual, as well as protect the environment by state or central government also. Hence, from 1986 onwards, our honorable judiciary played an important role regarding protection of environment by the constitutional amendments as well as laws made by the state government as well as laws made by the central government is considered. तर माझा मुख्य पहिला मुद्दा हा आहे की सुरुवातीला नव्हतं कॉन्शियसनेस, ओनली फायनान्शियल स्टॅबिलिटी इज इम्पॉर्टंट, industrialization is started, and by that growth the environmental consciousness, awareness or protection of natural resources या पद्धतीची थिंकिंग सुरू झाली 1986 नंतर. भारतीय राज्यघटनेमध्ये आमूलाग्र बदल झाले, कायदे अस्तित्वात आले राज्य स्तरावर आणि देशाच्या स्तरावर. ज्युडिशियरीला अधिकार आहे कायद्यामधल्या त्रुटी दुरुस्त करणे आणि कायदे मंडळाकडे देणे, आणि त्यात जर काही लूप होल्स असतील टू फिल अप द लूप होल्स, बिकॉज इंडियन ज्युडिशियरी इज नो डाउट द गार्डियन ऑफ आवर इंडियन कॉन्स्टिट्यूशन. दिस इज द प्रायमरी फंक्शन ऑफ हाई कोर्ट्स as well as Supreme Court is considered. So Indian judiciary played an important role, vital role in regarding the protection of environment. The first case come before Honorable Supreme Court regarding the municipality of Kanpur in the year 1986. There is a case of nuisance. There is a problem of drainage system. The fact of that case is some problem arising in drainage system and the nuisance or some interference or as well as the effect on public health. Matter is raised before Taluka Court. Taluka Court is not ready initially to take a cognizance. Again, matter is raised before District Court. District Court is also not ready to discuss that matter because this is the first case, Kanpur Mahanagarpalika versus Vradhichand. The matter of environment, whether may be discussed in court or not, such matter is having solution or not, the law is available or not, what guidelines may be given, what type of judgment may be delivered. So long list of problems are raised before the judiciary. But in that case, Honorable Supreme Court, again matter is after 13 years go to the Supreme Court, and Honorable Supreme Court in Kanpur Mahanagarpalika versus Vradhichand case directly held that nowadays the period is come to take a bold view, to take a bold decision. Protection of a public health is very important. Protection of a public, as far as public nuisance is considered. So protection of environment, right to livelihood in healthy condition, the judgment or gist of a case, the important guidelines, the important crux of the judgment is that the healthy environment is very essential for the all-round development of a personality. No doubt, growth of development of personality is important. Other factors are also responsible, but as well as healthy environment or right to wholesome environment is also most important thing is discussed by Honorable Supreme Court. From that case, the Honorable Supreme Court passed some guidelines, and Honorable Supreme Court clearly held that now period is come to discuss the issues or discuss the points regarding consciousness of people regarding environment or how the public nuisance affect the health of an individual. Supreme Court taking a cognizance and on the basis of that cause of action by Kanpur Mahanagarpalika, strict guidelines passed by Honorable Supreme Court and held that this is the responsibility of Mahanagarpalika. So every individual must be protected. Healthy environment may be given. Survival of human being, for healthy survival, healthy environment is essential. Again, that the scope is expanded by Supreme Court and held that purity of water, fresh air, nutritious food, these are the important points mentioned by Honorable Supreme Court and held that for the all-round development of a personality, the healthy environment is very essential. This is the first case. Second case is considered came before the Honorable Supreme Court in the year 1987. That case is very famous. That case is called as a rural litigation and entitlement Kendra Dehradun versus state of UP. This is also a very significant case which is decided by Honorable Supreme Court in the year 1986. In this case, the environment of a protection is most important. The most important second point recognized by Honorable Supreme Court is that there must be certain kind of a ratio between the development and the protection of environment. On one side, Supreme Court held that the facts are some in the case is that the main allegation in this case is that the mining operations are started and it affects on human health. In this case, Supreme Court giving certain balance between the development and conservation of natural resources important. In first case, Kanpur Mahanagarpalika case is considered healthy environment. This is the important guideline of Honorable Supreme Court. As far as rural litigation versus entitlement Kendra Dehradun versus state of UP is considered, the decision is delivered on 1986. In that case, Honorable Supreme Court clearly held that the ratio or balance between development and conservation of environment is important. We must place certain social obligations. These are the lines of Honorable Supreme Court, and we must place on record certain social obligation is most important one. Development is essential, but if natural resources are totally exploited, then what is the output of that development? What is the exact impact of that development? On one side, protection of environment, use of natural resources, not to exploit the natural resources, means ecological balance is most important one. So first time in this Dehradun case in the year 1986, Supreme Court clearly held that certain kind of balance is very important. Only government does not give importance to the development. Certain kind of attention on the conservation of natural resources, ecological balance is the most important. And in this case, the court awarded in the year 1986 10,000 rupees to this NGO because that NGO approached to the Supreme Court, and this NGO requested Supreme Court that no doubt these mining industries are giving employment, रोजगार अनेक लोकांना देत आहेत, विकास होतोय, but that vikas is not useful as far as exploitation of natural resources are considered. This development, mining agencies totally exploited our natural resources, totally imbalanced. Hence, that development is not useful as far as the Dehradun is considered. Thick forest is considered. Supreme Court accepted the request of NGOs and giving a compensation. This is first case in Honorable Supreme Court giving a damage to the 2 rupees, 10,000 rupees, and clearly held that certain kind of check on industrial growth is most important. From Kanpur case, consciousness is started. In the year 1986, Supreme Court taking a bold view. Supreme Court taking a dynamic approach and awarding rupees 10,000 rupees as a compensation to the Dehradun people due to exploitation of natural resources is considered. Third case come before Honorable Supreme Court. Now here I am citing only important cases which are called as a landmark judgments, which are called as a dynamic approach or giving some new vision regarding the protection of environment. And all those judgments are specially declared by Honorable Supreme Court or High Courts is considered. Second important case is oleum gas leakage, that is Shri food fertilizers case. The case is MC Mehta versus Union of India. This case is come before Honorable Court in the Honorable Supreme Court in the year 1987. One Shri Foods and Fertilizer Company, this is pesticide insecticide company. The fact of case is not that much important. This company, through that company, the leakage of oleum gas, and this oleum gas is very dangerous, in short poisonous. And this factory, that is Shri Foods and Fertilizers factory, is established near Tees Hazari Court in Delhi. In 1 year, there are total 3 incidents of leakage of oleum gas, and 3 persons are died due to this poisonous case. 3 times various cases instituted in the district court, taluka court, some damage is awarded, but in spite of that, the Shri Foods and Fertilizer case giving a defense that we are giving employment to thousands of persons. Hence, our employment is essential. Through that company, the production of pesticides, insecticides is essential for the farmers, etc., etc. With such defense, the companies come before the Honorable Court. Lastly, in the year 1985 on December 7, a tragedy has happened and one advocate of High Court is died due to leakage of oleum gas. MC Mehta, a great person in Indian judiciary, every advocate or the person who belongs to legal fraternity knows MC Mehta. MC Mehta is a senior person, leading practitioner, and he files approximately 50 to 60 cases regarding protection of environment. MC Mehta, leading practitioner, filed public interest litigation under Article 32 to the Supreme Court. And Honorable, in that case, MC Mehta requested, this is the third tragedy. This Shri Foods and Fertilizer case is a no doubt big employer, always giving certain type of defenses and escape their liability. तो असे डिफेन्सेस घेतोय की ज्यातून त्याच्या लायबिलिटी पासून तो दूर पळतोय आणि ह्याचा तिसरा प्रकार आहे ज्यामुळे लोक मरण पावतात. नाउ period is come to take a bold view. Before this judgment, the vicarious liability principle or the liability principle is available in the books. But when the MC Mehta requested Honorable Supreme Court that certain strict view, the principle of absolute liability was accepted in other Western countries. In India, only the principle of strict liability is available. By that strict liability, certain kind of defenses are available. That is act of God, etc., etc., inevitable accident, वगैरह वगैरह. कि फॅक्टरी वाले इंडस्ट्रीज वाले असं म्हणत होते की हा इन्व्हायटेबल ऍक्सिडेंट आहे, आम्ही काळजी घेतोय, पण घेऊन सुद्धा अशा प्रकारच्या घटना होत आहेत, इस्केप होतोय गॅस. त्यामुळे आम्हाला हेवी फाईन्स लावणे किंवा फॅक्टरी बंद करू नये. पण यामध्ये MC मेहतांनी माननीय सर्वोच्च न्यायालयाला स्पष्ट निदर्शनास आणून दिले की आता काळ बदलला आहे, जागतिक स्तरावर स्ट्रिक्ट लायबिलिटी हे प्रिन्सिपल अस्तित्वात राहिलेलं नाहीये. आता ऍब्सोल्यूट लायबिलिटी नावाचं प्रिन्सिपल अस्तित्वात आणा, जेणेकरून दॅट पर्सन इज हेल्ड ऍब्सोल्युटली लायबल. Not a single type of defense is available. Only the principle of natural justice may be followed. That is only right to hold. This type of natural principle, natural rule of law may be given to that person. But that person, if damage or natural resources exploit or any injury is caused to the environment, definitely that person is held absolutely liable. Supreme Court in this case, oleum gas leakage case or Shriram Foods fertilizers case, very big short industry, held that now period is come to take a bold view, to take a dynamic approach, and held that new principle is passed in the India, and that principle is called as a absolute liability. If any company is negligent regarding leakage of gas or regarding damage to the environment or exploit natural resources or pollution is caused, that company is held absolutely liable. Not a single type of defense is available to the employer. So this is third most important case regarding the protection of environment. And in this case, Honorable Supreme Court held a compensation of rupees 3 lakhs, initially 10,000. Within 2 years, the award remuneration or compensation may be increased from 10,000 rupees to the amount of 3 lakhs. So hence, this judgment is also called as a most important case, most important judgment, the vital role, important role played by Indian judiciary is considered. Shriram Foods and Fertilizer case in the year 1987. Next important case is we are very much familiar, that is Bhopal gas case. This incident is happened in the year 1990. No law is available. No doubt this company, Bhopal Gas Leakage company, is a very big shot company. Initially, they are not ready to accept the responsibility. But fortunately, our Honorable Supreme Court in the year 1987, in the case of Shriram Foods Fertilizer case, giving a judgment, passed a principle of absolute liability. By that judgment, Supreme Court clearly held that this company, Union Carbide company, where we all are very known with this company, very big short company, the company cannot escape the liability. In this case, the initial compensation of 250 crores of rupees, because thousands of persons are died in this case, due to the incidence of leakage of poisonous gas, that is methyl isocyanate gas is considered. So due to that leakage of gas, oleum lethal gas, methyl isocyanate gas, thousands of persons are died, thousands of persons are injured. In this case also, in Bhopal gas also, Supreme Court clearly held that a principle of absolute liability is passed. Here, long list of persons are died, as well as natural. This is not natural calamity. This is artificial calamity. Company is not much more conscious as far as the strict measures regarding leakage of gas is considered, and held the compensation of 350 crores to the Union Carbide company, etc., etc. This is most important case as far as the protection of environment or the protection of a human being is considered. This is third case regarding the protection of environment or the protection of a person is considered. Next important case law discussed is the case of Taj Mahal case. This is also most important case, right to survive in the healthy environment. Once again, in Taj Mahal case, Taj Mahal is situated near the Agra, and as far as the river of Ganga is considered, long list of industries, factories are started by big employers. And due to the leakage of gas, there is red coating on Agra. The original color of white Sangamram may be discharged, may not be, may be disappeared. And due to this coating, some damage is caused to the Agra. No doubt Agra is a national monument. Once again, MC Mehta, a leading practitioner, person who is very much conscious or alert regarding the protection of environment is considered, and he is filed a case in Honorable Supreme Court in the year 1987. MC Mehta filed a case, and in that case also Supreme Court giving a clear decision that all those industries may be shifted or may be closed. Shall be, not may. The word may is not used by Supreme Court. The word used by Supreme Court is shall be closed. That is mandatory, that is binding. Shall be closed if there is a loss of employment, then certain shifting, certain industries, certain factories may be shifted from Agra to some suitable places which may not be causing damage to the natural resources or environment is considered. This is also most important judgment delivered by Honorable Supreme Court regarding protection of national monument, that is Taj Mahal is considered. Another most important case which is passed by the Honorable Supreme Court recently in the year 2000 is considered. That case is called as a forest conservation case, or that case is called as a Godavaran versus Union of India, or this case is popularly known as a forest conservation case is considered. In hilly areas, especially the part of Arunachal Pradesh, Himachal Pradesh, or northeastern states are considered. In those states, there is a very thick forest, and nearby forest, long list of sawmills are started. By that sawmill, there is first a theft of trees, etc., etc. Means damage caused to the forest, no conservation of forest. Immediately, T.N. Godavaran is a social activist. He files a social interest litigation or public interest litigation and requesting Honorable Supreme Court that ongoing various long list of sawmills may be stopped, and if government is not ready to stop, then all those sawmills may be shifted from near forest to any other place which is suitable as far as to the state government or as far as the owner of sawmill is considered. Honorable Supreme Court accepting the request of Godavaran in the year 2000, and Honorable Supreme Court, as far as conservation of forest is considered, passed a landmark judgment, and all those factories, all those sawmills are shifted from forest area to such other places, approximately from 8 to 10 kilometers. Specific restriction is imposed by Honorable Supreme Court in this case also, and in that case also the conservation of forest by Honorable Supreme Court. This case is also called as a important case law as far as the protection or conservation of environment is considered. So from this case, it is clearly held that the Supreme Court, by the principle of judicial activism, by the principle of environmental jurisprudence, a new concept is developed, that is environmental jurisprudence or judicial activism. Supreme Court accepted the bold view or dynamic approach is very essential as far as the protection of environment, conservation of forest, or protection of natural resources are considered. The Supreme Court passed a landmark judgment, and in that judgment, Supreme Court clearly held that we can use the natural resources. That principle is called as a precautionary principle, polluter pays principle, etc., etc. Long list of principles are passed. Due to the paucity of time, I cannot explain all those principles. But short, Supreme Court clearly held that the responsibility lies on our shoulder. Use natural resources which are essential for us. Only those resources, maybe you can use it, but cannot exploit it in the name of development. Certain balance is very essential as far as development and protection of environment, conservation of natural resources are concerned. So this is important. Hence, Supreme Court clearly held that you can use natural resources and transfer to the future generation. That is called as a polluter pays principle, precautionary principle, sustainable development, or environmental protection is considered. Only on one side, development, financial stability, these things are not that much essential, that much useful as far as the protection of interest of future generation is considered. फक्त विकास 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 हाच महत्वाचा मुद्दा नसून मानवाचं हित आणि त्या मानवाचं हित हे निसर्गावर अवलंबून आहे. निसर्गाचंच रक्षण झालं नाही तर मानव राहणं शक्य नाही, मानवाची प्रजाती राहणं शक्य नाही. कारण अशा लॉंग लिस्ट ऑफ इंडेंजर्ड स्पेसीज आहेत ज्या प्राण्यामध्ये असतील, फळामध्ये असतील, वनस्पतीमध्ये असतील, अशी लॉंग लिस्ट सुप्रीम कोर्टामध्ये दाखल झाली. आणि ह्या ज्या इंडेंजर्ड स्पेसीज आहेत, इन्स्टिंक्ट म्हणजे ज्या नष्ट झालेल्या स्पेसीज आहेत, त्यामुळं ही जी काही लाईफ सायकल आहे मानवाची ती धोक्यात येण्याची शक्यता आहे. त्याच्यामुळं विकासाच्या नावाखाली नॅचरल रिसोर्सेस एक्सप्लॉइट करणं मानव जातीनं हे अयोग्य आहे. सरकारनं त्यासाठी वेगळे कायदे जरी केले असतील तर इम्प्लिमेंटेशन इज मोस्ट इम्पॉर्टंट थिंग. सुप्रीम कोर्ट क्लिअरली हेल्ड दॅट देर इज अ स्लॅक इम्प्लिमेंटेशन. सर्वात महत्वाचा मुद्दा अंमलबजावणीचा आहे. सुप्रीम कोर्टाने क्लिअरली सांगितले की ही अंमलबजावणी करण्याची गरजेची आहे. म्हणून केवळ सुप्रीम कोर्टाच्या निर्णयामुळं अनेक एन्व्हायरमेंट प्रोटेक्शन ऍक्ट सारखा सर्वात महत्वाचा कायदा अस्तित्वात आला. भोपाळ गॅसमध्ये जो युनियन कार्बाइडचा बिग शॉट असणारा आपली रिस्पॉन्सिबिलिटी ऍक्सेप्ट करायला तयार नव्हतं, त्याचं कॉम्पेन्सेशन 250 करोडचं 350 करोड्स वर गेलं. आता तर सध्या आपण पाहतोय की एन्व्हायरमेंटल कॉन्शियसनेस, एन्व्हायरमेंटल क्लिअरन्स असल्याशिवाय फॅक्टरीज इंडस्ट्री स्टार्ट होत नाही. सो इन शॉर्ट माय कन्क्लुजन इज दॅट डेफिनेटली for the protection of environment, Supreme Court, High Courts played a very important role, and due to the vital role, dynamic approach by our honorable judiciary, Indian judiciary, the development may be controlled, natural resources or protection of environment may be carried out. This is my conclusion. Thank you for giving me an opportunity, sir. Hello. Hello.
हाँ सर, माझा आवाज
Sir,
येत नाही सर.
any questions, sir? Any queries?
Just a minute, sir.
Okay.
Now I request, dear all participants, please, if you have any queries regarding the topic, please come ahead and ask queries. Sir will answer it. Dear participants. Okay, thank you very much, sir, for the nice presentation on the topic judicial response for the protection of environment. You explained so nicely, clearly, and step by step. You pointed out all those things. So that is why all participants have understood very well. So there is no point of the question. Now I request the chief organizer of the series, Honorable Principal Member, sir. Please come, sir, and have some words for the session. Welcome, sir.
Sir, sir, once again, on behalf of all participants, wish you happy birthday, sir. Please enjoy with you and your family, sir. Once again, best wishes, sir. Thank you.
Thank you, sir. Now
Thank
I
you, sir.
move towards the vote of Shri Kumarswami, Mahavidyalaya, Ausa, District Latur. As we know, organized the World Record Series 2. Today was the 156th day of the series, and the topic was very important one, that is judicial response for the protection of environment, which have been explained Honorable Dr. Mahesh Laxmanrao Dharmapurikar sir so nicely covered all those regarding the topic. At the very beginning, sir have mentioned the judicial approach to the environment protections. Then what is the role of judiciary in the protection of environment? What are the judicial remedies for the environment protections? And at last, how judiciary has responded to the forest conservation and different cases regarding the judicial response to protection environment. Now, all those points have covered so nicely, sincerely, clearly. Really, we appreciated a lot, sir, your lecture for today's session. So, thank you very much from the bottom of heart. Sincere gratitude towards you. Thank you very much. Then I
Thank
thank to
you,
the
sir.
Chief
Thank
Organizer
you,
of
sir.
the World Record Series 2, Honorable Principal M. Bedkar, sir. I thank the colleagues from my college, Dr. Sanjay Kale, sir, Anita Dole, madam, Dr. Sudhir Garar, sir, Karar, sir, Honorable Praveen Utge, sir, and all others. And lastly, I thank heartily to all those participants who joins the series regularly, motivates us, and enhance the beauty of the series. Sir, who always on the screens always join the series regularly. So thanks, special thanks to you. And now I request all the participants, please fill the feedback link which is given in the chat box. Now, with the kind permission of the chief organizer, I declare that today's session is over. So thank you very much. Bye bye. Take care. Good night.